In this lecture, we shall discuss termination of office. Termination of office. Termination of office. And we shall do the discussion under the context of contracts law. How do we terminate office that have been properly made? You realize that in our previous lectures, we have discussed what an offer is. We've also discussed what an acceptance is. Now, if you make an offer, how do you terminate an offer? Now, there are different modes of terminating offers. We can terminate an offer by withdrawal or revocation of the offer, by rejection of the offer, by a lapse of time, also it can be terminated if the offeror indicated that the offer will come to an end upon the occurrence of a particular event and that event has occurred, or on the death of the offeror. Now, I have to take each of these modes, these 5 modes, one after the other, and explain them. So the first one I shall deal with is revocation of an offer. Now, as a general rule, the main purpose of making an offer is that it is going to be made for it to be accepted. So the general rule is that if an offer is made and is not accepted, the offer can be revoked at any time before acceptance. That an offer once made can be revoked at any time before acceptance. So once an offer is made, it can be revoked at any time before acceptance. That is the common law position. Now, I have to move on to discuss those kind of offers whereby a person makes an offer and says that I offer you my vehicle for 10,000 Ghana cedis. This offer shall remain open for 3 months for acceptance. If you make an offer and you promise to keep it open for a period of time, is that offer and the promise to keep it open, is it binding on you in the absence of any consideration from the other party? So if I make a promise to keep an offer open, that I offer my car to you for 10,000 Ghana cedis, and I say this promise is open for the next 5 weeks, the promise to keep it open for 5 weeks, is it binding on me in the absence of any consideration from you? So the promise to keep an offer open for acceptance. The common law position is that the promise to keep an offer open for acceptance is not binding on the offeror if there is no consideration from the offeree. So the common law position is that the promise to keep an offer open for acceptance is not binding on the offeror, especially when there's no consideration flowing from the promisee. And this position has been affirmed in the case of Routledge and Grant. Routledge is spelled Routledge versus Grant. So Routledge and Grant says that if you make a promise to keep an offer open for acceptance, that promise is not binding on you unless there's any consideration from the promisee. So at common law, if I make a promise to keep an offer open for acceptance, and I said that I am making it open, that you can accept it within 5 months. If I accompany with the promise to keep it open for 5 months, at common law, I can revoke it at any time since you've not given me any money for me to keep it open for that 5 months time. That is the case of Routledge and Grant. Now, this position of the common law has been revoked in Ghana by the Contract Act of 1960 at 25. The section reads as follows. Contract Act of 1960 at 25. Contract Act of 1960 at 25, section H1. And it reads as follows. A promise to keep an offer open for acceptance for a specified time shall not be invalid as a contract only by reason of the absence of consideration, therefore. Again, a promise to keep an offer open for acceptance for a specified time shall not be invalid as a contract by reason only of the absence of consideration, therefore. Meaning that in Ghana, if you make a promise to keep an offer open for acceptance, you cannot say that you can revoke it at any time merely because the other party has not given you any form of consideration. In Ghana, a promise to keep an offer open for acceptance for a specified time shall not be invalid as a contract by reason only of the absence of any consideration, therefore. So in Ghana, if I make an offer to you, I offer to you my vehicle for 10,000 cedis, offer to remain open for 3 months. I cannot revoke the offer within the 3 months merely because you haven't given me any form of consideration. This is a modification of the common law position. Because you remember in the common law position we saw in Woodland and Grant that a promise to keep an offer open for a stated period is not binding on the offeror, so that the offeror can revoke it at any time before acceptance. But in Ghana, there's a modification under section H1, which says that a promise to keep an offer open for acceptance for a specified time shall not be invalid as a contract by reason only of the absence of consideration, therefore. Now, the next point to note about the revocation of an offer is that whenever anybody tenders a revocation, the revocation of the offer must be brought to the attention of the offeree. So if you, the offeror, if the offeror has made an offer and then you made it to the offeree, and you, the offeror, you are going to revoke the offer, you must make sure the person you made the offer to, he has received notice of the revocation. So if Kofi makes an offer to Amma to sell his vehicle to Amma, and Amma has gone around and is looking for loan to come and buy the vehicle, if Kofi is revoking or withdrawing the offer, he must make sure the withdrawal gets to the attention of Amma before it can begin to be effective. So revocation of an offer must be brought to the attention of the offeree. And you can see this in the case of Byrne. Byrne is spelled B-Y-R-N-E and Company versus Leon, L-E-O-N, Van, V-A-N, Tienhoven is spelled T-I-E-N-H-O-V-E-N and Company. So the notice of revocation must be brought to the attention of the offeree. And these are the facts. Take note of the dates. On October 1st, 1879, the defendants in Cardiff posted a letter to the plaintiffs in New York offering to sell them goods. This was on the 1st of October, 1879. Then on the 8th of October, 1879, the defendants posted a letter revoking the offer. The plaintiffs received the offer and telegraphed their acceptance on the 11th. So take note of the date. The letter of revocation was posted on the 8th of October, 1879. The plaintiffs received the offer and telegraphed their acceptance that same 11th. But the defendant's revocation arrived on the 20th of October. So take note of the dates. The offer was made on the 1st of October. Defendants revoked the offer on the 8th of October, but the revocation arrived on the 20th. Now, before that 20th, plaintiff had tendered the acceptance on the 11th. So the question is, was the revocation effective from when it was posted? That is on the 8th of October, or it was effective from when it was received? That is on the 20th of October. What did the court hold? The court held that the contract came into existence on the 11th of October. The 11th of October was the date on which the plaintiff telegraphed the acceptance. And this is because once it's a letter of revocation, it is only effective from the time it is brought to the attention of the offeree. So the letter of revocation was posted on the 8th, but arrived on the 20th. But before it arrived on the 20th, acceptance had been sent by the 11th. The court held that the contract came into existence on the 11th. So, as far as the contract is concerned, this is what the learned justice Lindy J said. And I quote, "In my opinion, the withdrawal by the defendants on the 8th of October of their offer was inoperative, and the complete contract binding on both parties was entered into on the 11th of October, when the plaintiffs accepted their offer of the first, which they had no reason to suppose had been withdrawn." So what is the court saying? At the time that you did the revocation, they had not received it and they didn't know that they had revoked it. So they communicated the acceptance on the 11th, and it is supposed to be deemed to be effective on that date that the acceptance was communicated. This is the case of Byrne and Company versus Leo van Tienhoven, that whenever you revoke an offer, you must make sure that it takes effect. It has been brought to the attention of the offeree. That is when it will take effect. So then, this is what we can say about notice of revocation, that it must be brought to the attention of the offeree before it will be deemed to be effective. One question that has usually arisen is this: that when the offeror is revoking an offer, the offeror must the notice of revocation come from the offeror himself, or it can come from any other party. Now, when it comes to offeror and is revoking an offer, must the notice of revocation come from the offeror himself, or it can come from any person? So, for example, if I have made an offer to you to sell my vehicle to you at 10,000 Ghana cedis, and I have revoked the offer today, must the revocation come from me myself, and I use the offeree? Are you supposed to receive notice of the revocation from me myself, or any third party can bring it to your attention? So if I make an offer to you to sell my car to you for 10,000 Ghana cedis, and tomorrow I change my mind, we have been told that the notice of revocation before it can be effective must be brought to the attention of the offeree, meaning that I must make sure the notice of revocation comes to your attention. No two ways about that. But must it come to your attention through myself, or any other person can bring it to your attention? Now, when you look at the case of Dickinson and Dodds, the answer to this question has been provided. The Dickinson and Dodds, it shall be very helpful to look at this case for it to determine that must the revocation come from the offeror himself, or it can be from a third party. This case demonstrates that the notice of revocation need not be from the offeror himself, and that it can be from a reliable third party. In other words, if the offeror makes an offer and intends to revoke it, can he revoke it and let a reliable third party bring it to the attention of the offeree? The answer is yes. That the revocation on the authority of Dickinson and Dodds need not come from the offeror himself, but can come from a reliable third party. And these are the facts of Dickinson and Dodds. On Wednesday, 10th June 1874, the defendants made an offer to the plaintiff to sell a house to the plaintiff, stating that, and I quote, this offer should be left over until Friday 9 a.m. On the Thursday afternoon, the plaintiff was informed by one Berry that the defendant had been offering or agreeing to sell the property to one Allen. This notwithstanding, plaintiff sought to tender his acceptance on Friday at 7 a.m. In fact, the defendant had already sold the property to Allen on Thursday, 11th of June. Let me explain what's happening over here in the facts. That first of all, the defendant made an offer to sell to the plaintiff a house, and he said the offer to be left over until Friday 9 a.m. But on Thursday afternoon, this same plaintiff to whom the offer had been made, he was informed by one Berry that the house that had been offered to him, it was being offered to another person for sale called Allen. Now, even though the plaintiff was given the information that the house that had been offered to him, it was being offered to another person for sale, the plaintiff still went ahead to tender his acceptance on Friday at 7 a.m. And he was doing this knowing well that he had already been informed that the property was being sold to a different person. And in fact, the property had already been sold to the Allen on Thursday, 11th of June. So at the time the plaintiff even brought his acceptance, it was even too late. Now, there was a question as to whether the Berry who told the plaintiff that the offer was being given to another person, whether he was somebody who could communicate the revocation. Plaintiff was arguing that if anything at all, it was the defendant himself that had to communicate the revocation to the plaintiff. But what did the court hold? The court held that the revocation need not come from the offeror himself, it can come from a reliable third party, and that Berry was a reliable third party, and therefore the revocation was deemed to be effective. Listen to the words of the learned Justice James L.G. And I quote, "It is to my mind clear that before there was any attempt at acceptance by the plaintiff, he was perfectly well aware that Dodds had changed his mind, and that he had in fact agreed to sell the property to Alan. It is impossible, therefore, to say there was ever that existence of the same mind between the parties, which is essential in point of law to the making of an agreement. I am of the opinion, therefore, that the plaintiff has failed to prove that there was any binding contract between Dodds and himself. So what we get from Dickinson and Dodds is that, please, if I make an offer to you, the revocation, we know already that you must receive notice of the revocation. But Dickinson and Dodds is saying that the notice of the revocation, it need not come from me or from myself. It can come from a reliable third party. So Dickinson and Dodds says that the notice of revocation need not be from the offeror himself, it can be from a reliable third party. Now, the next principle to look at is that you remember we dealt with unilateral contracts. We dealt with general office, like we saw in Kalon and Kabolet's book, where you can go on the radio and say that whoever can ride bicycle from Accra to Tamale, you shall pay him 10,000 cedis. Remember those offers, general offers. So those offers that you make on radio as well, unilateral contracts. How do you revoke those offers? Because if you made an offer that whoever can run from Accra to Kumasi shall pay me 10,000 cedis, and I started running and I've gotten to Konongo, can you revoke the offer at that point in time? Because remember, since I haven't gotten to Konongo, I haven't accepted the offer yet. Since I haven't gotten to Kumasi, I haven't yet accepted the offer. Your instruction was quite specific that whoever can run from Accra to Kumasi, 10,000 cedis. I haven't gotten to Kumasi yet. Can you revoke the offer at any time that you so wish if I haven't finished completing the performance? The case of Errington and Errington is very instructive in this regard. Errington and Errington. Errington is spelled Errington versus Errington, Errington, and Woods, reported in 1952, 1 King's Bench at page 290. Errington versus Errington. This case laid on the position that once the offeree has started performing the act amounting to the acceptance, it is not possible for the offeror to revoke the general offer. Once the offeree has started performing the act amounting to the acceptance, it is not possible for the offeror to revoke the general offer. These are the facts of the case. A father purchased a house in his own name. He promised his son and daughter-in-law that if they would pay off all the mortgage installments due on the house, he, the father, will transfer the house to the son and daughter-in-law. They duly paid the installments, But when the father died, the widow sought to revoke the offer. Think about it carefully. And father says that if you paid off all the mortgage, I'll transfer it to you. The people have started paying. They have paid the installments. Now that the father has died, the widow says that I'm going to cancel this arrangement. This is a clear case of once the offeree has started performing the act amounting to acceptance, it is not possible for the offeror to revoke the general offer. This is what was held by Lord Denning. And let me read the express words of Lord Denning. And I quote, "The father's promise was a natural contract. A promise of a house in return for their act of paying the installments. It could not be revoked by him once the couple entered on performance of the act. But it would cease to bind him if they left it incomplete and unperformed, which they have not done. If that was the position during their father's lifetime, so it must be after his death. If the daughter-in-law continues to pay all the building society installments, the couple will be entitled to have the property transferred to them as soon as the mortgage is paid off. So you see what Odani is saying? He said it could not be revoked by him once the couple entered on performance of the act. And that's very key. And that's why we mentioned over here that once the offeree has started performing the act amounting to acceptance, then the offeror cannot revoke the offer. This is Lord Denning in Errington and Errington. So if you make a promise to me that whoever can run from Accra to Tamale, you shall pay me $10,000, and I run and I get to Kumasi, you can't say that you are revoking it, because everything is saying that the moment performance begins, you cannot revoke it because it will be unfair to me. So once the offeree has started performing the act amounts to acceptance, it's not possible for the offeror to revoke the general offer. And the authorities for this are Errington and Errington and Salisbury versus Salisbury. This is quite recent. Salisbury is spelled Soulsbury versus Salisbury, Soulsbury, 2007 EWCA Civil Division 969. Now, when you make a general offer to the whole world, like we saw in the newspaper, how do you revoke those kind of offers? How are offers that are general offers revoked? You advertise in the newspaper that anybody who can run from Accra to Tamale, you shall pay this amount of money. And you want to now revoke this offer. How do you revoke it? The law is that you must revoke it in the same prominence, with the same prominence that you made the offer for. So if you made the offer in the newspaper, Daily Graphic, you must go and revoke it with the same prominence, in the same medium that you made the offer. Other than that, you can't go and make the offer in Daily Graphic, then you go and revoke it at Common Song Magazine. You see, if you do that one, it will be unfair. How can you go and make an offer on television, then you go and revoke it on some radio that has about 20 people listening to it? So the revocation of a natural offer, you must revoke it with the same prominence and the same medium that you made the offer for. And we'll see this in Luxor Limited versus Cooper. In Luxor Limited versus Cooper, it was held that once you make an offer in a particular medium, then you must make sure that you revoke it in the same manner, with the same prominence that you made the offer for. And now let us go to the facts of Luxor and Cooper. The facts are as follows. The owners of two cinemas offered the plaintiff £5,000 each if the plaintiff were to introduce persons who would purchase the cinemas. Now, even though the plaintiff introduced purchasers who were willing to pay the price, the sale did not take place because the owners declined to proceed. The plaintiff was therefore prevented from completing the purchase because the owners declined to proceed with the sale. So look at the facts carefully. We'll pay this amount if you're able to give us people who come and buy the properties. Now, even though he brought the people, we didn't complete the sale. We didn't sell it to them. But the plaintiff still went ahead to sue the owners, claiming 10,000 commission. Alternatively, £10,000 in damages for breach of implied term by the owners not to do anything to prevent him from earning his commission. It was held that the fact that the commission to be paid by the agents was payable only on completion of the transaction. By the nature of the contract, the offeror reserved the right to revoke at any time before completion. So the offeror reserved the right to revoke at any time before completion. And if they have revoked it, the revocation is effective. And since he didn't bring people to buy it, the people didn't buy it, so the sale was not completed. So he's not entitled to any commission. Because the agreement was that bring people, when they buy, we pay you commission. The people you bought, we didn't allow them to buy it. So there's no commission to be paid to you. We have revoked the offer, and you cannot be allowed to claim any commission. Now, the very key case you need to know about revocation of general office is the case of Shuey. Shuey, everybody must know this case when it comes to revocation of general office. Shuey versus United States. Shuey, S-H-U-E-Y, Shuey versus United States. Very old case, 1875, of the U.S. Supreme Court. It says that a general offers to persons who can be described as unascertained offerees can be revoked through the same medium and the same channel as the offer was made. A general offer to persons who can be described as unascertained offerees can be revoked through the same medium and the same channel as the offer was made. These are the facts of the case. Shuey versus United States. Very interesting facts. On 20th April 1865, a proclamation had been published which offered a reward of $25,000 for the apprehension of a particular criminal. About 7 months after, i.e. on the 24th of November 1865, a notice revoking the offer was also published. I'll take the fact again. On the 20th of April 1865, a proclamation had been published which offered a reward of $25,000 for the apprehension of a particular criminal. About 7 months after, i.e. on the 24th of November 1865, a notice revoking the offer was also published. The plaintiff, who was unaware of the revocation, discovered the criminal in 1866, informed authorities, and then sued to claim the promised reward of $25,000. Again, on the 20th of April 1865, a proclamation had been published which offered a reward of $25,000 for the apprehension of a particular criminal. 7 months after, a notice revoking the offer was also published. The plaintiff was unaware of the revocation, and he discovered the criminal in 1866. He informed the authorities and then sued to claim the promised reward of $25,000. What do you think? Even though the revocation had been published, the plaintiff was not aware of it. But he went ahead to apprehend the criminal. And now that he has sued for the money, he is saying that a revocation was published. But he wasn't aware of the revocation. What did the court hold? The court held that the offer had been effectively revoked at the time that the plaintiff discovered the criminal and informed the authorities. The offer had been effectively revoked at the time that the plaintiff discovered the criminal and informed the authorities. And these are the words of the judge. Very, very key words. And I quote, "The offer of a reward for the apprehension of Shuey was revoked on the 24th day of November 1865. And notice of revocation was published. It is not to be doubted that the offer was revocable at any time before it was accepted. And before anything had been done in reliance of it, there was no contract until its terms were complied with. Like any other offer of a contract, it might therefore be withdrawn before rights had accrued under it. And it was withdrawn through the same channel in which it was made. The same notoriety was given to the revocation that was given to the offer. Emphasis: the same notoriety was given to the revocation that was given to the offer. And the findings of fact do not show that any information was given to the claimant, or that he did anything to entitle him to the reward offered until 5 months after the offer had been withdrawn. Let me take this part again. Like any other offer of the contract, it might therefore be withdrawn before rights had accrued under it. And it was withdrawn through the same channel in which it was made. The same notoriety was given to the revocation that was given to the offer. And the findings of fact do not show that any information was given by the claimant. True, it is found that then and at all times until the arrest was actually made, he was ignorant of the withdrawal, but that is an immaterial fact. The offer of the reward not having been made to him directly, but by means of a public proclamation, he should have known that it could be revoked in the manner in which it was made. You see, the offer of the reward not having been made to him directly, but by means of a public proclamation, he should have known that it could be revoked in the manner in which it was made. And what is very important here is that the judge said that true, it is found that then and at all times, until the arrest was actually made, he was ignorant of the withdrawal. But the court says, but that is an immaterial fact. So the fact that he was ignorant of the withdrawal is inconsequential. What is important is that the revocation was done through the same medium that it was made. This is how we revoke general office. This case of Shuey versus United States, that you revoke general office by giving the same prominence to the revocation, using the same medium that's used to create a general offer. So if you make the general offer on the radio, go and use that same video to revoke the offer. If it was a newspaper daily graphic, use that same newspaper with the same prominence to revoke the offer. Listen to what the judge says strongly. He says, the offer of reward not having been made to him directly, but by means of a proclamation, he should have known that it could be revoked in the manner in which it was made. And so the principle we get from Shuey versus United States is that a general offer to persons who can be described as unascertained offerees can be revoked through the same medium and the same channel as the offer was made. So we are discussing all this because we are looking at the modes of terminating offers. And we've dealt with the first one of withdrawal, when we dealt with the case of Routledge and grants. Over there, we mentioned that at common law, you can revoke an offer at any time before acceptance, so long as there's no consideration. But we look at the modification done by Section 8.1 of the Contract Act of 1960 at 25. That says that when you make a promise to keep an offer open for acceptance, it shall be binding on you, even if the offeree has provided no consideration for it. So you make a promise that you're keeping your offer open for 3 weeks, that promise will be binding on you, the offeror, even though there may be no consideration coming from the offeree. We saw in Dickinson and Dodds that whenever you revoke an offer, the revocation need not be conveyed by the offeror himself. But Dickinson and Dodds say that the fact of the revocation or the withdrawal can be communicated to the offeree by a reliable third party. We're saying in Errington that when you make a unilateral offer, when you make a general offer, then the moment the person begins performance, you cannot revoke the offer. Once the person has started the act amounting to the performance, you cannot revoke it. And since Shuey versus USA, that's it, that if you are going to revoke an offer, you must give it the same prominence and the same medium and the same channel with which you made the offer. That's Shuey versus USA. So all of these will help you understand one, withdrawal or revocation of office. Another way of revoking office is by rejection by the offeree. You remember when we did Hyde and range, counter offers? That the counter offer had the effect of destroying the main offer so that it cannot subsequently be accepted. So if an offer is made to you and you're not happy, you can reject it. Once you reject it, you cannot come back and accept it. An offer can also be terminated by lapse of time. The law is that once an offer is made, it must be accepted within a reasonable time. If not, then it will lapse. That is Errington and Kingful. Errington is spelled A-N-N-I-N-G versus Kingful, K-I-N-G-F-U-L. Reported in 1980 Ghana Law Report at page 404 that an offer, when it's made, is supposed to be accepted within a reasonable time. And if you don't accept it within a reasonable time, it will lapse accordingly. Another way of terminating offers is that an offer may be terminated if the offer stated that it will come to an end upon the occurrence of a particular event, and that event has occurred. So, for example, if I say that this offer that I've made, it will be valid so long as the war between Russia and Ukraine continues. But it will come to an end the moment the war ends. It means that the moment the war ends, you should know that the offer has what? Terminated. So an offer may be terminated too if the offer is stated that it is supposed to come to an end on the occurrence of a particular event, and that event has taken place. The offer too will begin to be terminated. And then finally, an offer too can be terminated by the death of the offeror. The person makes an offer and he dies. General rule is that the offer stands terminated. These are the different modes of terminating an offer. And this shall bring us to the end of our lecture on offer and acceptance. And this is where we shall draw the curtains. Thank you.